welcome. I'm George Sisby-Durrant. I'm a senior solicitor in the Brodie's planning team, but I'm English and English qualified, but do both sides of the border work, and joined with Neil Collar, who's the head of the planning team at Brodie's. So today we're just going to talk about the use classes order in England. Use classes are an important part of the planning system and kind of the use and control of land. So kind of leases can refer to permitted use classes, whether you can need to apply for permission or whether you benefit from PD rights, and perhaps if it can go down to the viability of a property transaction. So it's important to know about use classes and kind of what you can and can't do with your property. Now today we don't want to go through the UCO in detail because you've probably had that before, and we're not going to go into a lot of detail on the reforms of 2020, so the Class E, for example, just because there was so much done about that. Instead, we're hoping to look at some kind of specific areas where there are either grey areas or they kind of raise questions of use classes, and so yeah, hopefully it'll be useful to you to kind of focus in on a few. These are obviously a non-exhaustive list of things that are kind of grey areas, I suppose. There's plenty more, but this is just a select few that we've decided to talk about today. If I'm sure some of you on the webinar will have potentially had experience with these areas, so these topics. So any thoughts and kind of experiences you have or insights, please pop them in the Q&A. That'd be really great to have that discussion at the end. So I'm going to hand over to Neil first for the first bit.
Right, thanks very much, George, and good afternoon, everyone. I thought before we go in and actually look at individual use classes and some of those grey areas that George was talking about, it would be useful just to talk through some of the concepts and the general approach, because I think we can dive too quickly into talking about use classes and actually forget what the real issues, as it were, actually are. The first three bullet points are really the key bits of background. Is the change material? When is the use ancillary, and what's the planning unit? To some extent, it's quite awkward to divide those up separately because they are quite interlinked. And maybe to start with whether the change is material, the point there is it doesn't matter what the use classes are. If the change of use isn't material, planning permission isn't required anyway. And I think there's a tendency to forget, and as a result feel that a change from one use class to another is necessarily material. It probably is, but you've got to stop and ask the question. The interesting example maybe to look at briefly is short-term holiday lets, which is a big issue in Scotland at the moment. The legislation authorising control zones is being implemented in parts of Scotland at the moment. But the general issue outside of control areas is whether there's a change of use from either it being a house or a flat. And the difference there is a use class issue, but not particularly relevant for the purposes that I'm talking about here. The point being that the case law is an English decision, which actually I've now completely forgotten the name of. It might be Moore. We're trying not to mention too much case law today, just avoiding it becoming too detailed. But the point is whether the holiday accommodation is an actual change from a residential use is a question of facts and circumstances. In Scotland, it's rather become assumed that a holiday accommodation is a material change, but there are occasional appeal decisions where reporters, our equivalent of inspectors, have decided it's not a material change, so planning permission isn't required. So that's just an example that you do in every situation have to say planning permission is only required if there is a material change of use, not just a change of use. The ancillary use point is perhaps looking at the same thing, but from a slightly different perspective. So it's a different question. There isn't a change of use if a use is introduced or evolves that is ancillary to the main use or the principal use, the predominant use, however you want to describe it. And perhaps the interesting examples from the list on the slide are working from home and personal trainer studios, again at home. And the personal trainer one was an English court case where the court said it was open to the inspector to decide that a personal training studio in the instructor's home was not ancillary. And although the individual could have used it as a home gym, it wasn't being used as a home gym, it was being run as a business. And the particular aspect inevitably are the comings and goings of the customer. And the court, as is the normal approach in these situations, the court's not the judge of the facts and circumstances. It just looks at the rationality of the approach taken by the planning decision maker. And here they said they couldn't fault that approach. The point about the working from home, very relevant in current circumstances where there's still quite a lot of working from home going on. Generally speaking, I think most folk would feel that a professional services type activity, particularly where you're not actually physically meeting clients and they're coming backwards and forwards to your house, is probably ancillary to the residential use, or certainly if it's not ancillary, I suppose going back to what I said, there's not a material change of use. So whichever way you kind of cut the cake, as it were, working from home, if it's an office type scenario without much increased activity, then that probably doesn't require planning permission. It's when you've got increased customers or increased deliveries or that sort of thing that it might become an issue. The final question there, in many ways, it actually should be the first question. And that's the starting point is to ask, well, what's the planning unit? Because that is the baseline for then judging what the use is. And then if there's a change of use either that's happened or is proposed, the materiality of that change. And that was something that I think it was George touched on in the last webinar we did, the English case law update, that there was a case involving Manchester City Council where the council had analysed the situation on the basis of the whole building, and the court said that was incorrect because there were 4 individual units within the building, and if the planning unit approach had been properly applied, rather than it being a mixed use, which was sui generis, it would actually have been classes A1, B1 and D1. So that was an example where they'd got off on the wrong foot. And as a result, the approach was flawed. And the correct approach, starting point, is to look and say, well, what's the unit of occupation? And the interesting example of that, delving into historic case law, was one where the court said the metro centre in Gateshead it's not the centre that's the planning unit, it's the individual trading units within the centre. And you can see how that makes an enormous difference, because as each unit is occupied and commences use, that sets the planning use, and therefore the changes of use that might be possible either under the use classes order or with permitted development rights without requiring a planning application. And it also means that that occupation can supersede any flexibility that's in the main planning permission, and that's something we've educated real estate colleagues on through the years, that although the main permission can be fairly flexible, once each unit commences use, that flexibility flies off, as it were, and you then have to look at, as I say, use class order or permitted development rights in terms of the specific use to see whether or not a new permission might be required. The other example we wanted just to touch on here, again, just to illustrate these basic concepts. Supermarket cafes. Is it a cafe, or is it part of the supermarket in simplistic terms? And to some extent, the permission might separately authorize the cafe because it might be specifically mentioned in the description. But again, it's going back to my point about depending on the unit of occupation, the actual use can make a difference. And the point I'm driving at is if the cafe is operated by the supermarket, then the unit of occupation is the entire supermarket. And you look and you say, well, what's the predominant use? And you may well decide that the cafe is actually just ancillary to the supermarket, just because of the scale. And it may also make a difference if the cafe is only accessible through the supermarket, etc., etc. But many use classes orders are not definitive. It's very much, it depends. The point being, though, if the cafe area is actually operated by a different operator, whether it's through a lease or a concession or some sort of arrangement, it's a different unit of occupation. So the unit then becomes the cafe area itself. And as George is going to discuss later, cafe within separate use class. So the analysis changes and changes of use and things need to be looked at differently. So if the lease or the concession came to an end and the supermarket operator got that part of the floor space back, it may well be that they would need to apply for a planning permission for a change of use to whatever use they were going to make of it, rather than relying on the main permission. So that's a fairly quick rattle through these kind of key concepts that embed the whole operation of the use classes and to some extent permitted development rights flowing from them. So I'm now going to pass back over to George, who's going to look at some of the specific use classes.
Thanks very much, Neil. So the first one we're going to look at is kind of this residential with care or residential care home. So the kind of the classic supported living, assisted living scenario. It's something that I've done quite a lot of previously, working for a funder of supported living. So had quite a lot of exposure to it. And from that experience, just realized there's so many different levels of kind of care packages that are provided. So, and you've obviously got whether the care is a resident or non-resident, whether you've got self-contained flats or bedrooms with communal space, if there's on-site offices for the care staff, or potentially emergency kind of bedroom for carers if they need to stay over. So there's so much a spectrum of care offerings in assisted living. It does kind of drag into kind of what use class is it. So on the screen there's the potential ones. The one which I think most operators are aiming for is C3B, so the use of a dwelling, whether or not as a main residence, by not more than 6 residents living together as a single household, and then where care is provided for those residents. Then you've got C2, which is your traditional care home, so residential accommodation for care for people in need of care other than within class C3. You may have it as a C4, which is an HMO, if there are no more than 6 people living together that aren't a single household. And because the use classes order doesn't specify care or no care, it's presumed it can still be one. And I worked on several that required HMO licenses that care was being provided. But then what about sui generis as well? Because some councils think actually it doesn't quite fit into C3B or C4, and it's not as extreme intense as C2. And so it does kind of sometimes need sui generis use. So for example, if there are 7 residents with care, it would take it above that C4 level. So yeah, it's a big spectrum, and arguably it could also be your traditional dwelling house of C3A if there's 1 resident and the carer just comes in, so once a day, and kind of just does a few jobs but doesn't really kind of offer that much. So it's a bit of a grey area because you need to get it right in order to make sure that you haven't breached planning control, etc. Obviously, it is easiest if you have planning permission for it, because that will state what the council think it is. And often, if it is C3B, you'll find that a planning permission will limit PD rights, so that it will restrict it to C3B and require planning permission otherwise. But where it's a change of use, it's a bit more tricky. So obviously within C3, subject to being any planning conditions to the contrary, it will not be development, it will be fine. But then if the level of care provided takes into C2, so a care home, that would require planning permission. If it goes from a house to up to 6 people living not as a single household, so as an HMO, then you've got the PD rights from C3 to C4 and vice versa. And then you've got obviously anything that is to a sui generis use. Some will be more obvious. So if you have, let's say, a 6-bedroom house with 2 living rooms and one of the living rooms turned into an extra bedroom, that will become 7. It's therefore not HMO. But where the council think it's a sui generis use and it doesn't quite fit into those other classes, that's when you kind of have to look into is there a material change of use that means that planning permission is required. Helpfully, courts and inspectors have said, as Neil suggested earlier, kind of it's very dependent on facts and circumstances, and things they've sort of picked up on in the past are obviously, are they actually living as a single household, because that will distinguish whether they can be C3B, and part of that question is, are they physically capable of living as a single household? So there was the North Devon case in 2003 that said that children are incapable of being a single household. They are perhaps, they may be a single household if there is a permanently resident carer, but if it's shift carers and carers are coming around the clock, but it's not one person resident there, an adult, then they're not capable of being a single household, therefore they can't be C3. Other things to look at are obviously how much care provision, how often are carers coming in, how many carers are there per residence, and kind of, are they cooking for them, or are they just kind of perhaps doing laundry or kind of checking up and doing some cleaning for them? One interesting inspector's decision said that one of the factors they took into account was the way the household lived, and in particular they said that actually the residents had formed friendships within the group and they would cook together, share the jobs, etc. around the house, and so to them that's what kind of, there were other things in favour, but that was a factor that contributed to it being a C3B use, so within a single household. And as I mentioned earlier, kind of what's the layout like? Are they self-contained flats? Are there locks on the bedroom doors? Do rooms have an ensuite, and do they have kitchenette facilities, or is everything communal? So there's such a different breadth of kind of examples of assisted living that kind of it is purely on the facts, and you just basically have to make a judgment call on it. But hopefully this session will kind of expand on some bits of it and just explore it. So just got some examples. So I've already mentioned the North Devon case. Oh, sorry, backslide, Lorna, if that's right, please. Already mentioned the Devon case, which said children can't, and in order for a carer to be considered part of a single household, they need to be resident, so even if there's 24-hour cover. And so obviously any children who are over 16, if everyone's over 16, they then can live as a single household. In an inspector's decision in Barking and Dagenham, the council said that to accommodation that was helping to prepare young people to live independently, they considered that was C2. The inspector, however, looked at the house layout and the facilities, and this was the one where the residents had formed a friendship and they shopped together, cooked together, and it was much more of a communal experience that they considered that actually they did live as a single household, and so overturned the council decision. Another one in 2016 in Nottinghamshire, which is quite helpful. So this involved 5-bedroom house. 4 of them had en suites. 1 was next to the communal ground floor bathroom. All of the rooms had locks on their doors. The visitors were required to sign a register. So perhaps thinking a bit more like maybe it's edging to C2 or a sui generis kind of situation. But again, the inspector noted there was a lot of communal living within the layout, and kind of that went towards it being a C3B use. And they actually said even kind of at times when it went up to one-to-one carers to residents, they still suggested that actually it was still C3B. And what was quite a clarifying statement was they said the purpose of the carers in that situation was largely to assist as opposed to undertaking the day-to-day tasks, which kind of is sort of in the name in assisted living. But so that's why I put that on the slide there, that kind of it's not just looking at the care, not looking at the residents only, it's kind of looking at it in the whole of, is this an assisted living or is it a residential care home accommodation? So yeah, that's just some examples and some factors to think about, but it is subject to kind of just looking at all the facts and the circumstances and making a call on it. As I said, getting planning permission is the easiest option. Okay, so the next topic, Lorna, next slide, if that's all right, please. Thank you. So looking at kind of bars and restaurants, particularly the sort of the gastropub and that sort of area. So since 2021, pubs or other drinking establishments, so kind of wine bars, etc., they're now sui generis instead of being A4 use, and there's an additional sui generis category, which is a drinking establishment with expanded food provision. So you've obviously also got the your class EB, which is your restaurant use, kind of just for consumption on the property. And what's not on that slide is there are PD rights between a pub and drinking establishment to kind of a pub with expanded food provision. So there's between those two sui generis classes is now PD right. What's important to note though is you can't use that PD right to slowly merge into a class EB restaurant. But kind of the situation I want to look at is kind of what about, so you've got your gastro pub, which could be a drinking establishment with expanded food provision, which is that sui generis class. It could be more a pub with just an ancillary dining aspect, or in some ways, I mean, there are some perhaps slightly more higher end gastropubs that looks like and smells like a restaurant. It just is in an old pub building. So it's that's kind of the area we're trying to look at here in terms of that grayer area of kind of slightly more, perhaps more the other way around of the sui generis class. So instead of a drinking establishment with food provision, it's a food establishment, i.e. restaurant with expanded drinking provision. And an example I had was when I was in London, and next to my old office there was a restaurant that had a bar area which was serving just the place where they serve the drinks to the restaurant customers. But on sometimes Thursdays, Fridays, Saturday nights, especially in the summer, it was frequented by people from the offices nearby after work for drinks. And to the extent that the majority of the customers in there would have been people having a drink, not actually people visiting the restaurant. So then kind of thinking of that, is that the restaurant use with an ancillary drinking establishment element, which kind of is ancillary, so it's fine? Or is it a hybrid restaurant drinking establishment situation? Because if it is, then that's probably a mixed use and so sui generis. Or perhaps is the bar element a non-material change of use in practice, and that will depend on various factors, kind of as Neil suggested, and kind of looking at, I suppose, impact of the change. And I mean, in this case, people would often flow out into the outdoor seating area and beyond. So I don't know the planning position of this restaurant, so I can't comment if they were lawful or not, but I frequented it, so it's fine. And I suppose just to round it back to those three factors before, although it's unlikely, is there a different planning unit at all? Probably not, because it was very much kind of not in the circumstances, but just food for thought on those. And I'll pass back to Neil now for dark kitchens.
I see you got the pun in there about food for thought. I was also reminded of the client who explained to me that they were definitely a restaurant use because they didn't do vertical drinking, which was the first time I'd come across that concept. But what he meant was they don't have people standing up drinking, you have to sit at a table, and it's a slightly different perspective on it all. On dark kitchens, it's another example of how the planning system needs to deal with new concepts. If you've not heard about a dark kitchen before, it's not a kitchen where there's been a power cut. It is a unit, probably not in a central area somewhere cheap, and all they do is cook, and primarily for food delivery, although as with all of these things, you have to be slightly careful to actually find out what the individual use is, rather than just assuming that you know because someone said, oh, it's a dark kitchen. But within that sort of parameter, again, interesting questions posed about what the use class is, and the slide summarises it there. I think it is maybe settling into an acceptance that it's probably a light industrial process, just because if you go to the use classes order and look at the definitions, an industrial process is defined as a process for making of any article. And if you take individual ingredients, cook them up, you produce a food product that is an article. So it would appear to be a light industrial process, assuming the odors and everything are reasonably well controlled. The general feeling is it's not a hot food takeaway because the customers don't actually arrive, it's the delivery service. But I suppose there is scope for running that argument that it doesn't necessarily need to be the customer who takes it away as long as it's being taken away. but there have been some instances where councils have felt that it's sui generis use. And that tends to be a bit of a pattern when new concepts come along, that a lot of councils seem to jump in and feel it must be sui generis, rather than actually trying to fit it in to an existing use category. And unfortunately, that's a bit typical of how the planning system works, that councils tend to be very wary of creating a situation where permitted development rights can be exercised where they don't get to control things. And sui generis is the easy way out of that, because if it's sui generis, you need planning permission to institute the use, and then if you're going to change it into anything else, you also need planning permission so the planning authority can exercise control. So dark kitchens, as I said, just an interesting example of something new, raising issues for the planning system. And I'll pass back over to George, who's back to food for thought because he's looking at sandwich shops and cafes.
Grand, thanks, Neil. I will perhaps whiz through this one a little bit because we've had a couple of questions, which would be good to get to at the end. But this is perhaps more for an issue currently in Scotland, but it was previously in England as well before the reforms. But when is a sandwich shop a cafe and vice versa? So on the screen again, we've got the three potential use classes. So we've got the retail class. So previously was a different category from EB, which is now restaurant use. And then you've also got kind of sui generis, so the sale of hot food. And for takeaway, sorry. So obviously there's freedom of change of use between EA and EB, so actually it makes it not too difficult. But if you take Scotland, for example, class 1 is the retail sale of non-hot food for consumption off the premises, and class 3 is kind of your restaurant use. So you can see where perhaps in Scotland and where we had it before class E, it's a bit more of an issue. And obviously you can have some element of hot food takeaway, and we know that they sometimes do, but that's normally going to be ancillary. So I'll just quickly for this point just kind of go through a couple of the classic high street cafes or coffee brands. So start with Pret, and there are other ones obviously available. If you look at Pret's model, they're mostly takeaway generally, but obviously it's cold food, it's sandwiches. You might have the odd panini toasted. I haven't been to Pret recently, but yeah, so any sort of hot food element will definitely be ancillary. And similarly, any sitting in to be that class EB would also potentially be ancillary. But it does depend, because if you go to some Prets, I know there's one near the Barbican in London where it's enormous and it has loads of seating area, whereas if you go to others, they're literally just like they're there to pick up sandwiches and maybe like 2 seats. So again, like just you have to in those circumstances look at kind of what's the principal use. Is the seating area ancillary? So in Scotland, for example, if there's an excessive amount of seating and like the majority of people eat and drink then that may be more class 3 rather than class 1. Previously in England class A3 rather than A1. And I suppose with Pret as well, they give you takeaway cups rather than porcelain cups. But on the other side, you've got say Starbucks and Costa. They obviously have they're more balanced between people sitting in having coffee and taking away. Perhaps Nero goes a bit more sitting in than takeaway. It just depends. Then that just kind of balance. Like you when you think of Pret a Manger and Costa and Starbucks, you think, other than perhaps your different tastes of their coffee or opinions of their coffee, you sort of think they're the same thing and they would fall in the same use class. But actually, if you look at their business models and even between their shops, between different locations, you can see how there is actually quite a diversity in their uses, and therefore kind of what use classes it technically fall in. Is planning permission required? Most likely, probably not. But it's just on this one, it's just something to think about and kind of throw some ideas around. As I said, now that we've got Class E, that kind of solves the problem slightly. But in Scotland, we don't quite have that, and perhaps this is an example of where something similar to Class E in Scotland would be useful. And I'm going to hand over back to Neil briefly on that point.
Thanks, George. Lauren, if you can maybe give us that slide. Thank you. George has been touching on the way through about the differences between England and Scotland. And as the slide notes, the Scottish Government do have a consultation open at the moment. It's actually on permitted development rights, but it includes a proposal for some sort of town centre use class, which, well, they actually specifically say that something similar to Class E would have some potential merit, which is quite interesting civil service speak, I think, for yes, well, maybe. They don't want it to include the business light industrial element, Class 4 as it is at the moment in Scotland, although they do propose there could be an element of permitted development rights for that. And as the slide mentions, some element of permitted development rights for outdoor furniture for cafes and restaurants. That became a feature during the pandemic, just as a relaxation, looking to keep that in some way. The slide mentions their permitted development rights for town centre residential conversion. That's actually something that, although they're consulting on it, they're saying they're not minded to introduce it. Not a use class order issue as such, but just an interesting one to note on the way past. So that's very much one to look out for, because as I said, it's quite an open-ended consultation question. The proposals are not particularly rigid at the moment, so there's scope there for interesting responses. That takes us on to the question period, and thank you for the people who submitted the questions. George, just before I launch in fairness to you, there's a question about the use class C3 issues. Have you had a chance to read that?
Yeah.
You have. Okay, good, because that means I can read it out, but know that you're going to be able to answer it. The question says, some councils are requiring applications for a change of use from C3A to C3B. Maybe actually, if I pause there, can you remind us what the difference between C3A and C3B is?
Yeah, C3A is people living as a single household, just as your normal residential home. C3B is for that kind of provision of care for people living as a single household.
Right. So the question is saying some councils are requiring an application for change of use from the former to the latter for single households where care is provided. For example, 2 18-year-old men living as a single household, each with non-residential carers. This would have very serious implications for anyone who lives independently but has carers visiting on a daily basis. These cases appear to be motivated by a desire to clear out C3B uses from primarily residential areas. But the person posing the question is saying, surely this cannot be a material change. So that's picking up what I mentioned about if there's not a material change of use, then you don't need planning permission for the change in the first place.
Yeah, sure. So I think perhaps what councils are relying on here is technically C3A, the purpose of the definition of a single household goes back to the Housing Act, which basically you have to be related. I think that's off the top of my head though. And C3B, you don't need to have that relationship. You just have to be living as a single household. So, but even then, C3A to C3B, I think what the council's saying is actually it's probably currently an HMO, so C4 to C3B, but then that's got PD rights. So unless they've taken those away, of course. But I think they're completely right in terms of surely it can't be a material change. It does depend on how often the carers come in and the toing and goings, etc., and whether let's say that the two gentlemen are perhaps disruptive for neighbours, and does that take it to a material change of use? Yeah, it does seem a strange one. I can't give you a definitive answer, but yeah, I wouldn't have thought it would require planning permission, but depends if the council think that it's a sui generis use rather than a C3B specific use.
Thanks. And it, I think, has parallels with a Scottish Court of Session decision. And unfortunately, this is where it gets complicated, because the specific use class provisions are different. So putting that bit to one side, the broad thrust of the court's decision was that non-residential carers did not take it outside of a residential use because they weren't considered to be part of the household because they were non-residential. I've maybe not summarised that terribly well, but I think there's an interesting parallel there, just to show that focusing too much on the existence of non-residential carers isn't maybe a determining issue in it all. A couple of other questions, just quickly before we finish up. We'll be a minute or two late, but I'm sure no one will hold that against us. A question about drive-throughs, and presumably this is the food and drink sector, whether it's driving through for a burger or a coffee or indeed both, and just asking what use class that would be. I think you kind of answered that without directly answering it already, but if you could remind us about, it's hot food takeaway, isn't it?
Yeah, I think it would probably be hot food takeaway, but then, well, firstly, it'd usually be covered by planning permission. So, for example, if it's part of a retail park, it will usually say cafe with drive-through facility, or kind of hot food, fast food restaurant with drive-through. But there's also that element, I suppose, is the drive-through element ancillary to the, because if you think, let's take a McDonald's, for example, probably 50% of people go in there to take away anyway. So then what's the difference if they're in the car or not? Is that a material change? Is it ancillary? Yeah, I think usually it would probably be kind of fine and part of the ancillary to the main use, especially because it's so similar.
And in use class terms, it would be sui generis because of, well, if it is truly a hot food takeaway, as opposed to, as you were saying, if it's part of a restaurant use, or indeed it might end up being such a mixture that it tips into sui generis. Just depending on the circumstances. And then the final question was going back to your discussion about pubs and referring to tap rooms, which the questioner is saying seem to be classed as shops, whereas most of them are really pubs. I'm not actually terribly sure what a tap room is, but I think in many ways that's the questioner's point, that it's very easy to stick labels on. I think it kind of feels like it's alluding to sampling before you buy, maybe, almost.
Well, I think kind of where straight from the brewery, like say Bermondsey Bilmar, for example. But yeah, I mean, I would probably agree that they look and smell like a pub. Having been to them before, like they very much act like a pub, whether they are the shops is a strange one when I suppose you look at the definitions in, what is it, EA, that kind of says the retail sale of goods. Yes, there would be, but I'd have thought that the sui generis use of drinking establishment would be more applicable to it, or potentially if it also offers some food, which some I know do, then it would obviously be that other one, which is drinking establishment with expanded food provision. But yeah, it's strange if they're considered as shops, and maybe that's a slight misunderstanding from the relevant council as to what goes on in a tap room, I suppose. But yeah, it's
well, again, it's possible that it depends on the circumstances, because I can think of one in Edinburgh near Haymarket Station that I visited, which I think is described as a tap room. It's very small. I visited to buy to take away, and there was as much space devoted to the product for sale to take away as there was space to actually sit and drink. So possibly there might be some like that, which we must visit sometime and have a proper discussion about.
We'll do some market research near this time.
Yes, and indeed anyone else who's on this webinar who wants to join us in Edinburgh to have a discussion about this, it sounds like the ideal place to do it. Thank you to everyone for those questions, and thank you everyone for tuning in today. If there is anything that you want to pick up with us, our contact details are there. You'll have got the main gist of it, that the important thing is actually just look at what the order says. Always go back and remind yourself, because it's the actual legal provisions that matter, but equally it's the facts and circumstances. So it is difficult to be definitive, and all of these sort of new trading formats will continue to pose issues for the planning system, and I'm sure in years to come we'll be doing similar webinars and having similar chats, because questions will always be there. But thank you all for your time, and have a good evening when it comes. Thanks.
Thanks all.